Assalamualaikum warahmatullahi wabarakatuh, and hello everyone. I am NORERYSHA SHAHIERA from Group 3 as the moderator for the team discussion for an intellectual property case specifically on the case for KUANG Food Products Public Company Limited against the Wish Marketing Co. Sdn Bhd. So, this case will be discussed thoroughly in this video, starting with Muhammad Arif that we deliver about the fact of this case, and then we will proceed with the issues of the case that will given by Muhammad HAZIM, and then we will continued by Muhammad Danial that he will explain further on the judgment of the case, and last but not least, we will proceed by NABILA NAJWA that will speak about the opinion towards this case. Without wasting any more time, let us together discover about...
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Arif and I'm from Group 3, where I will be delivering the facts about the case of my case. It's between KUANG Food Products Public Company Limited against the Wish Marketing Co. Sdn Bhd on the case of logo and trademark copyright. The plaintiff is KUANG Food Products Public Company Limited and the defendant is Wish Marketing Co. Sdn Bhd. And the case took place in High Court in Sabah, in Sarawak, Kuching, Malaysia. The plaintiff contests that defendant had been manufacturing and distributing canned sardines like theirs, with a similar get-up in packaging with the word Smiling Brand as opposed to Smiling Fish, which appeared in the addition to pictures of a blue-coloured sardine and chilies. The plaintiff alleged that the depiction of these marks on the defendant's canned sardine is an infringement of their copyright, causing irreparable damage to their business goodwill, reputation, and make them suffer loss and damage. The claim of the plaintiff is that the defendant copies their name and trademark and change a bit of their brand name as well as their trademark, and it is confusing the consumers. The plaintiff company is a company from Thailand and has been distributing their products in Sarawak for the past 20 years. While the defendant is a local company that has been in the business for 11 years. The case more difficult to judge is that the companies are in the same business field and the defendant is once the plaintiff distributor. The plaintiff terminated their contract way back in 1998. Their contract were terminated because they had attempted to hijack the Smiling Fish trademark by applying for registration of the same get-up on 1987. But the defendant denies that the alleged and they claim that the plaintiff motive was all about business because they are trying to monopoly the business. And that is some of the facts that I want to deliver about this case. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad HAZIM bin HASKAM, and today I'll be presenting about the issues for the case of KUANG Food Products Public Company Limited versus Wish Marketing Corporation Sdn. For this case, there are three issues that have been agreed by both parties, which is the first one is to prove that the defendant has infringed the plaintiff's trademark, which is Smiling Fish brand and device, and adopting it to the defendant's brand, which is Smiling. The second one is to prove that the defendant have used almost identical get-up compared to the plaintiff's get-up, and the third one is to prove that the defendant has infringed the copyright law by using artistic work from the plaintiff's side. From the plaintiff's side, there are several issues that have been raised. The first one is they claim that the defendant are using their brand identity, such as by using their pictures, words, and sound to be marketed. For the defendant, second one is the words used by the plaintiff, which is Smiling Brand, were almost identical as the words that have been used by the defendant, which is Smiling Brand. The third one is the theme color used by the plaintiff, which is almost orange, are also used for the defendant's branding. The fourth one is the blue fish as illustrated in plaintiff's product have been used on the defendant's product with almost the same angle and had to be identified with the naked eye. And the last one is the background picture that are used by defendant, which contains sardines, vegetables, and red chilies beneath the sardines are almost identical with plaintiff's product, especially in terms of its arrangement. For the side of the defendant, they claims that the get-up used by the plaintiff only shows at one side of the product, whereby their product shows the get-up at both surfaces of the products. That's all from me. Thank you.
Greetings, my name is Muhammad Danial bin FAIZAL and I'm from Group 3. Today, I'm going to present about judgment of this court case. Judgment relates to one of the most widely consumed food in Malaysia, which is the canned sardine food. Basically, in the market of Kuching, Cebu and Miri, it appears that there are two identical canned sardine from a different company. Therefore, a Thailand company which has a legal copyright of the smiling fish issued an infringement of copyright to the local brand named Smiling Brand. The Smiling Brand, which is the defendant, has used almost identical packaging design. If we observe closely, there are differences between the design. However, the customer might not notice the differences in their design because if you look from afar, the design looks alike. So, the defendant canned sardine is resemblance to the smiling to the plaintiff packaging appearance give the impression that the plaintiff has authorized or consented to the manufacture for distribution and sale of the defendant canned food, which could lead to the public confusion and deception. The plaintiff had therefore commenced an action on 12th of November 2009 for the alleged infringement of their trademark. On 20th of May 2010, the court granted an interlocutory injunction against the defendant for causing goodwill, reputation, and copyright infringement with refund of security deposit of 100,000 to the plaintiff.
Hello, my name is NAJWA binti SUHAIMI. By going through the detail about this case, I would like to give an opinion. The plaintiff has the right to issue charges against the defendant due to the illegal infringement of plaintiff Smiling Fish trademark canned sardine product to the defendant Smiling Brand trademark. This is because the plaintiff registered the trademark and used it more than 10 years, but defendant have applied the register that brand name but still pending approval by the relevant authority. So this is the reason why the trademark is so important for your product, either for small or big commercial, because registered trademark is crucial in safeguarding for your brand. If you have registered your trademark, you as an owner are allowed to take legal action for someone who use or attempt to use it without your permission. Next case is about the defendant are illegal of their copyright the design of a plaintiff's get-up, which is have the same color scheme adapted, the very same blue tinge fish with a background of a delicious sardine garnished with a green vegetable and the picture of a red chilies under the fish. And this will give a confusion for the customer to buy the canned sardine, either the both canned sardine in the same company or not. If that happens, the plaintiff has suffered or is too likely to suffer damage or injury to his business and goodwill by reason of the said action. In intellectual property, a literacy, musical and artistic work shall not be eligible for copyright unless the work has been written down or recorded. For this case, the get-up design, which is an artistic work from plaintiff, was copyrighted by the defendant. Thus, the copyright protection is very important. From beginning until end of the judgment session, the plaintiff has put in enough the evidence to show that they have been marketing their canned products, including sardines, under the same trademark since 1984. In other hand, there is a little that the defendant could present by way of evidence to counter this assertion of fact, but the defendant was attempted quite unsuccessfully, in my opinion. I believe on the evidence presented that the plaintiff's canned sardines having been in the market for so long. That's all from me. Thank you.